22nd day of December 2025. Good afternoon, my dear students. I hope you are all fine, relaxing, planning for your exam. This your lecturer has come again. Subai will not allow us rest because he is not resting himself. Yes, I am not allowing you to rest. I want to tidy up my lectures on liquidation of companies so that I will send you away with a good taste in your mouth. Don't worry, when it comes to exam, I will see how to accommodate some of you. So, in the first lecture, if I recall, we looked at some key topics. We looked at types of winding up, and I don't want to go through that again because you already know about it. If you're not sure, you take your time and then listen to those lectures, please. So in this class, we are going to take it to another level. We will see what we can do in the next 1 hour by looking at other related matters, other matters related to winding up. We will try and look at priorities in insolvency or winding up. We will look at regulating wrongdoing during winding up. And we will also look at the liquidation of unregistered companies. We will look at fraudulent trading and then wrongful trading. And then, God willing, I should be able to release you. Then the next lecture I will send should not be more than 30 minutes. We'll just run through key actors in insolvency. So let's start with priority in insolvency. It's not new to you. You're already aware of it. When we looked at debentures, if I recall, sections 203, 205, and all that, gives us the hint. Section 657 is the primary section to look at in priorities in insolvency. Who takes first, essentially? And I told you that the law recognizes different types of creditors of the company. There are senior creditors and then there are junior creditors. Senior creditors can be classified as secured creditors or preferential creditors. Secured creditors and preferential creditors. And in secured creditors, we primarily are talking about floating charge holders, because fixed charge holders often tend not to have any problem. Liquidators cannot touch their money. Liquidators cannot do much to them, so they don't really have much problem with priority in insolvency. In fact, from the onset of insolvency, I think I talked about it in the last class, when winding up commences, all actions against the company's assets will have to be stayed or suspended, but that does not extend to fixed documents that are subjected to a fixed charge. So when we're talking about preferential creditors here and fixed secure creditors, essentially our focus is on floating charge holders, and then our focus is also on preferential creditors. So what the law does is to create a hierarchy of creditors, if you may, a hierarchy of creditors. And in that hierarchy, you will see that first of all, we have preferential creditors. After that, we now have the floating charge holder. After him, we now have the preferential. After him, we have the unsecured creditor. After him, we now have the preference shareholder or preferential shareholder. Then equity shareholder is 0. They rank last. So you want to take your time and look at section 657. It's quite a long read, 7 sections. Perhaps I'll read it. What it does is that the focus for priority in insolvency is on fixed charge. Preferential creditors of the company and floating charge holders. Fixed charge holders are not bothered that much. Like I said, one main reason is because even the liquidator cannot go after assets that are subjected to fixed charge. So if you look at section 577, for example, when a company is being wound up by the courts, any attachment, sequestration, distress, or execution put in force against the estate or effects of the company after the commencement of the wind-up is void, provided the provisions of this section do not apply to a fixed charge or any other validly created and perfected security interest other than a floating charge. So floating charges are subjected, but the fixed charge holder, again, if you recall when we talked about administration, when we looked at it, the administrator doesn't have much powers against a property that is subjected to a fixed charge the way he does with respect to property that is subjected to a floating charge. So I just felt we should just note some of those facts. Okay, so going on, we have to rush. Priorities in insolvency. First thing, having liquidated the company, the hypothetical scenario is that the liquidator has a number of assets in his hand. We expect him, first of all, from those assets to handle all the costs of liquidation. Then so he can pay that, he can sort that out, after which he will now sort out the preferential creditors. And here we're talking about taxes, payee, pensions, and all that, deductions meant for pension, deductions meant for tax, what we call payee tax, that he has not been making, salaries of clerks, workmen, etc. 657 or 647, please. And then, so these monies are all to be paid equally, they all rank equally. We don't look at first time, first in, first out, first in, first out. No, they all rank equally for all purposes. And then you discharge them in proportion. So debts are to be discharged immediately if the assets of the company are sufficient to meet them. They are equal, they rank prior to debentures secured by floating charges, but not over fixed charges and all that. So that is something you want to know. You want to take your time to still look at section 657. So taxes, all local rates and charges due from the company, and to be paid within 12 months immediately before the date, all payee taxes, property, basically taxes, then monies you are supposed to deduct for employees, so, and deductions made from the remuneration of employees and contributions. So under the pension reform scheme, the employer is meant to deduct some monies from the employee, and then At the same time, he is also to bring something from his pocket and to invest that money in a pension fund administrator. If he has not been doing that and the company is being liquidated, then those deductions are first line obligations that must be sorted out in priority to floating charges, on other creditors and all that. Contributions and obligations of the company under the Employees Compensation Act, you are meant to be making some contributions to a fund in the event that employees have issues and all that. All wages and salaries of any clerk or servant in respect of services rendered to the company are also to be paid. They are all in priority. All wages of any workman or laborer, whether payable for the time or for piece of work in respect of services rendered to the company, all accrued holiday remuneration becoming payable to any clerk, servant, workman, or laborer, on the case of his death to any other person in his rights, on the termination of his employment, before or by the effect of the winding up order or resolution, the right of a person who advances money for the payment of wages and salaries of clerks, servants, workmen, and then laborers, debts. So I say they rank equally after the expenses of the winding up have been paid in full. If they are insufficient, they are to abate in equal proportions. So it is after you have sorted out this category of persons that you now step down to the next level. You want to see that in section 657. Just a minute. 657 subsection 6. Notwithstanding the foregoing and any other provisions of this act and any other law applicable in Nigeria where it relates to settlement of claims in the winding up of the company, claims of secure creditors as defined under this act shall rank in priority to all other claims, including any preferential payment under this act or any other debts inclusive of expenses of winding up, and the equity holders shall rank last. So basically that is that. So in essence, this is the priority that has to be complied with. But again, it's important that I emphasize here that when section 657 subsection 6, let me share my screen with us. So okay, so 657 subsection 6 is to the effect that notwithstanding the foregoing and any other provisions of this act and any other law applicable in Nigeria where it relates to settlement of claims in the winding up of company, claims of secured creditors as defined under this act shall rank in priority to all other claims, including any preferential payments under this act or any other debts inclusive of winding up expenses. And B, the equity shareholders or equity holders shall rank last. When we mean secured creditor here, we're talking about a fixed charge holder or a mortgage holder. It does not include the floating charge holder. Very important. So if the company has secured the assets of Blessing Yaku with a fixed charge, and for one unfortunate reason that asset is destroyed or stolen, and the liquidator now comes to wind up this company, he sells all the assets that he finds, and what he has is 100 naira. What he has is 100 naira in his hand to now settle the creditors of the company. He has different expenses to make from this 100 naira. Blessing Yaku is an asset or the money the company was owing her for which it charged an asset created a fixed charge in our favor was worth 20 naira. You pay blessing out of 100 naira. You will pay blessing Yaku first. 18 naira will be left. It is from the 18 naira that you will now sort out the expenses of winding up. When you are done with that, you will now sort out the preferential creditors. When you have done that, you will now sort out the floating charge holders and then the preference shareholders. So we have preferential creditors and preferential shareholders. Sort out first the secure creditor. Here we're talking about fixed charge holder or mortgage holder, mortgagor, no mortgagee. When you have sorted them out, you now sort out the expenses of winding up. Then preferential payments, taxes, employee compensation, and all that. Then you step down a bit to floating charge holders, then unsecured creditors, then preference shareholders. If anything is still left, equity shareholders. When you have sorted out the equity shareholders, if anything is still left, you distribute whatever is left to the shareholders in proportion to their investments in the company. So never you mistake this secured creditors here. Never you mistake it to be to include a floating charge. Don't do that. Okay, so let's continue, please. I believe you have an idea on the law on priorities in insolvency. And I thank you for your time. So we continue. Now we want to now look at some other aspects of insolvency, which I have tagged regulating misconduct during insolvency, just to emphasize that when a company is being liquidated, a liquidator is appointed. That is the time when this person is able to now detect and determine whether there has been wrongdoing in the course of managing the company. A lot of wrong things can happen in the course of winding up a company, particularly when it becomes obvious to all that this company is going to be liquidated. That is when the devil goes into action. Directors become reckless. Either they can involve themselves in wrongful trading to the detriment of the company's customers. They can be involved in wrongful trading aimed at defrauding people or acting recklessly. They can involve themselves in what we call fraudulent preference. The company has 3 creditors, for example, creditor Yaku, creditor Esther Jeremiah, and creditor Edafe. The 3 of them are ranking equal because they are all floating charge holders. The company can now enter into what they call fraudulent preference because they love Edafe more to give him an advantage. Also, during the time of insolvency, the company can quickly create a floating charge in favor of Blessing Yaku or convert an unsecured credit into, I don't know why I'm having it. Combine and convert an unsecured credit in favor of Edafe into a floating charge in order to give him security over Esther and Jeremiah and Blessing Yaku. So these are all some things that can happen. There's also what they call undervalued transactions, particularly when insolvency has started. The company can sell its assets to somebody like, and you are my friend, and Primo. Now I can say, Primo, you are my friend. This company is going down. Come and buy the vehicles of the company for free or for next to nothing. So those are what we call undervalued transactions. So there are several provisions in CAMA designed at regulating such misconduct, designed as regulating such misconduct. And we are going to look at them presently, if you may, and see what we can do. Okay. So let's say a few things about fraudulent preference. I've already given you an idea. The moment insolvency starts, what we call the onset of insolvency, when the company goes into winding up or administration, if the directors of the company, if the company enters into an act, an act of procurement that gives undue advantage to a creditor, surety, or guarantor, such act is invalid. Similarly, any attempt to convey or assign conveyance or assignment of a company property to trustees in furtherance of such preference would also be void. Section 658. It is quite a very important section that deals with fraudulent preference. Sorry. Thank you, Lord. Okay, so you want to see that in section 658, 660, 658 and 660, essentially. So we'll just try and see what we can do with these sections to understand the law relating to fraudulent preference. But again, in a nutshell, any attempt, once a company is going down, like I told you, that is when directors and officers of the company can start being funny. And one of the things they may want to do is to dissipate the assets of the company or to give other creditors or some persons undue advantage over others. So any act or procurement designed as giving undue advantage to a creditor, a surety, or a guarantor is invalid. So if I'm a creditor of the company, and then Blessing Yaku is also a creditor of the company, if the company is going down, both of us would have to probably will have equal rights, and I may not have priority over her, neither herself over myself. But in order to give me undue advantage over her, the company can now secure my money with a fixed charge over its assets. That charge did not exist in the past 10 years. Well, now, the moment we see that the company is going down, we quickly say, and Supericom, we have now secured your money that were owing you 10 years ago with a fixed charge over this boss, so that once this company goes down, you will have a direct priority against the liquidator and against the Blessing Yaku. Similarly, with respect to for example, like I was saying, and once insolvency sets in, certain persons in the company may require protection, one of which could be a surety or a guarantor of the company, a surety or a guarantor of the company. On the other hand, creditors may also be vulnerable if they are unsecured, or if a person is a floating charge holder, and there are so many other floating charge holders. The floating charge holder, he's going to be vulnerable to preferential creditors, to the liquidator, and then to the fixed charge holder. So the company can quickly convert its floating charge to a fixed charge, or it may convert an unsecured credit to a fixed credit. That is a fraudulent preference. It can convert an equity investment and make it a preferential share. So I have an ordinary share. While insolvency starts, I convert my shares to preference shares. So that, again, just to give me priority. That is one side. That is a fraudulent preference. If the aim is to give you undue advantage over others. The second way it can work is a company has borrowed money. ABC Nigeria Limited has borrowed money from UBA Nigeria. It has 3 directors. And these directors have personally suretyed or guaranteed the repayment of this loan to the bank. You know that the moment this company becomes insolvent, the creditors of the company are going to proceed against these directors who personally suretyed this money. The moment they see that this company is about to be dissolved, they quickly take the remaining assets of the company. Listen, the guarantors who are directors take the few assets of the company to pay ABC Nigeria Limited. Once they do that, the liquidator is appointed. He will discover that these 2 directors who would have borne liability to the bank, they are now free. But in being free, the creditors will now discover that the pool against which they can proceed is now limited. The directors now have an undue advantage over the creditors. I give you another example. I'm a director and I have guaranteed money that the company borrowed from UBA Nigeria Limited. From the onset of insolvency, I now see that this company is going down. And once it's going down, the banks will proceed against me. I quickly take one of the assets of the company and use it to create a charge or a fixed charge, in the benefit of the bank. So that the moment this company goes down, the bank will not proceed against me, they will proceed against that asset. I have protected myself. From the onset of insolvency, all that is wrong, because the aim is to give you an undue advantage over other relevant stakeholders that the company may have. I want to read some aspects of that section while you see it, and we continue our discussion on the law relating to fraudulent preference. You are so good, God. There is none like you, God. None compares to you, God. I give you the praise, for you are so good, God. And you are loving, God. Okay. Where a company at any time within the period defined in subsection 6 does anything or procures anything to be done which has the effect of putting a person, being one of the company's creditors or a surety or guarantor, undue advantage shall be deemed a preference of that person and be invalid accordingly. Notwithstanding subsection 1, a preference given to any person is not invalid unless the company which gave the preference was influenced in deciding to give it by a desire to produce in relation to that person the effect mentioned in subsection 1. What is the effect? Undue advantage. So unless there's that intention to create an undue advantage, it is not an undue advantage. The fact that the act of the company gave me an undue advantage over other creditors or over other guarantors of the company is not the main thing. First of all, the act must create that undue advantage. Secondly, it must have been done with an intention to so create. A company which has given a preference to a person connected with the company, otherwise than by reason only of being its employee at the time the preference was given, is presumed, unless the contrary is shown, to have been influenced in deciding to give it by such a desire as is mentioned in subsection 2. In essence, if the person that enjoyed this preference is a person who is connected to the is a person who is connected with the company, like a director, or a person connected to the director, his wife, his children, underage children. Once that the person benefiting from that preference is connected with the company, the presumption is that we don't need to establish an intention to create an undue influence, undue advantage. Once it's a connected person, prima facie, by default, that act of preference was done with an intention to give him undue advantage. So the burden will now shift to him, unless the contrary is shown. It is now for him to now rebut that presumption by giving adequate evidence, unless he was an employee. If he was an employee of the company and the preference was given to him only because he was an employee of the company, then that presumption will not automatically arise. The fact that something has been done in pursuance of the order of the court does not, without more, prevent the doing or procuring of that thing from constituting the giving of a preference. Somebody can quickly, smartly procure the blessing of the court to an act of preference that he intends to be involved in. And we are saying that the fact that the judge, sometimes, for example, let me give you an example now. Two parties can file a case in court and say, my lord, we have both agreed, blah, 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 and to do this. And the judge just approves, consent judgment, and there's no opposition. The fact that there was no opposition, and then this act of preference, supposedly so-called, was done with the permission of the court, does not itself give validity to that act. So the fact that something has been done in pursuant to the order of the court does not, without more, prevent the doing or procuring of that thing from constituting the giving of a preference. Any conveyance or assignment of a company by a company of all its property to trustees in furtherance of the preference for the benefit of all its creditors is void. Any conveyance or assignment by a company of all its property to trustees in furtherance of the preference for the benefit of all its creditors. The directors of the company cannot attempt, to contract out of insolvency law. Once this company goes into insolvency, all the assets of the company should be left for the liquidator to deal with. So you cannot attempt from the onset of insolvency to convey or assign all of your property to trustees for that trustee to hold, even if your so-called intention is for the benefit of all the creditors. Once that assignment is done in furtherance of the preference, you are preferring one creditor over the other, then you are wrong, and that action is essentially void, because your plan at this time is to undermine the court and the liquidator, and to also distort the order of priority, because the trustee you are assigning this property to is not bound by the rules of insolvency. It's only the liquidator who is so required to do that, and he has rules he must follow, section 657 and all that. So I felt you should know that. Let me go back to my slide, please. Thank you, Lord. Okay, so please stay with me. We'll soon be done. Now unto the Lamb upon the throne, we raise a sound, we raise a sound. Ooh, are there some defenses the company can have? Yes. That the act was not done with the intention of giving a person undue advantage. There was no such intention. That is the primary defense. So secondly, the preference, so-called, the act that arose or gave rise to the so-called preference was to a connected person who was also an employee of the company. And if that is the case, then you could not automatically presume the existence of an intention to create such a preference. What if it was done in pursuance to a court order? I've already said that. I've already said that if it was done in pursuance to a court order, that does not automatically stop the act from being a preference and all that. Okay. This is because otherwise the company may engineer preferential outcomes by obtaining consent judgment or uncontested orders shortly before the insolvency. The focus is on the effect of the act and the company's intention, not simply the existence of judicial approval. So the primary time when we look at when this preference begins is from the onset of an insolvency. Section 658, subsections 6 and 7 are very crucial. I'll read. In the case of a preference which is given to a person who is connected with the company, the relevant time when that preference should have been given is the period of 2 years. If you look at your camera, you see a period of years. It ought to be a period of 2 years. Why did I say 2 years? Because if you look at CAMA 1990, that is what you will see. If you look at the English Companies Act, that is what you will see. If you look at other related provisions as well, you will see 2 years. So I want to believe that is an omission from CAMA. The period of 2 years ending with the onset of insolvency. And in any other case, the relevant time is a period of 3 months ending with the onset of insolvency. So if the preference was given to a person who is connected to the company, then we start to look at, because they are insiders. They are insiders working in the company, and then they ought to have had access to the books of the company. If they want to be funny, they would have had a long time. So for them, we will not wait till almost 3 months to say that is the onset of insolvency. We say any mago you did within the past 2 years leading up to the insolvency of this company can be deduced as being an attempt to create fraudulent preference in the favor of somebody who is connected with the company, except you can prove that that person and that act was given to him only on the basis of him being an employee of the company. Maybe the company wanted to reward him for his hard work, then will not say that attempt to reward him was done with an intention to give him preference, unless the contrary is proven. And the relevant time, okay, so 2 years. Then I said in any other case, maybe you are dealing with creditors now, you are dealing with sureties, guarantors who are not connected to the company, maybe a bank, a financial institution. If you want to give one guarantor, one surety, or one creditor an undue advantage over the other, at what time do we begin to count? We say we begin to account from 3 months. 3 months ending with the onset of insolvency. So if insolvency starts in, let's say April 1st, they will start to count from January, February, March. I think that should be February, March, April, February, March, April 1st. So 3 months ending with the onset of insolvency, which started from the 1st of April. So for the purpose of this section, what is the onset of insolvency? We're talking of from the time the petition is presented for the winding up of the company, or the passing of a resolution for winding up of the company. For the purpose of this section, the onset of insolvency refers, 1, to the time of the presentation of a petition for winding up, in the case of a winding up by or subject to the supervision of the court, or the passing of a resolution for winding up in the case of a voluntary winding up. So Again, the section applies in the case of a company where the company enters administration or goes into a liquidation. So, my dear friends, in a nutshell, this is the law relating to fraudulent preference. If the court finds that really that action that was done by the company was an attempt to fraudulently prefer one creditor over the other, or one surety over the other, what will the court do? The court essentially will bring you back to the position you were in before that attempted preference. Section 660. Let me just read the section so that you get the gist. Let me leave it. What, in essence, in a nutshell, what the section does is subject the person so preferred to the same rights and liabilities, as the rest of the company's creditors, guarantors, and sureties, as if he had sureted the debt to the extent of his charge on the property or the value of his investment, whichever is less. Determine the value of his interest as at the date of the preference. So then determine it as if it were free of all encumbrances other than those for which the charge of the company's debt was subject. So in essence, the preferred person loses the special advantage, is put on the same footing as all other creditors, guarantors, or sureties, is regarded as having merely guaranteed the company's debt rather than holding a preferential charge. Note, however, that his exposure is capped. He is treated as a surety only to the lesser of the value of the charge on the property or the value of his investment in the company. Okay, so when you get my slide, you can look at it. You don't have so much time and still have a lot to cover. Thank you, Lord. So I gave some examples which you may look at when you get my slide. Good. Let's continue. So section 662 is a straightforward section. It's possible again during the liquidation of a company. Like I told you that this again is similar to a fraudulent preference. A company will quickly create a floating charge with the intention of benefiting one creditor over the other so that he will have a priority. Section 662 is to the effect it avoids all floating charges created 3 months to the commencement of winding up of the company, unless the company was charged immediately after creating the charge. The second, let me see. I don't think it was charged. 662. Unless the company was solvent, able to pay its debts immediately after creating the charge. So not that a company is going down and then you are creating a floating charge to give one creditor a preference over other unsecured creditors. Or the company actually received cash when the charge was created. If the company actually received cash, that is a different ballgame entirely. This section is designed at addressing cases whereby either the company had been owing this man for long and it was an unsecured creditor, and suddenly we create a floating charge in his favor. It's again similar to giving him an undue preference, so. But if the company actually received cash, that means it's an actual transaction. It's not a fraudulent transaction, it's an actual transaction. Then that charge, whether it was created 3 months or 2 months to insolvency, would not be void. But if it was created without any money moving hands, then we know that you are just trying to be funny. You want to just give one person undue advantage over the other. Please, let's move on quickly. You can take your time and look at section 663. It has to do with disclaiming of onerous property. disclaiming of onerous property. A liquidator who is liquidating a company, his own is, he has powers. I think that should be is that the schedule 11 or so. He has all manner of powers to go after the assets of the company, manage the company, manage its assets. If in the course of doing this, he now discovers that some of the assets of the company are totally useless to him. Not only are they useless, they are burdensome. They are burdensome. The law allows him, with the leave of the court, to disclaim them. So even rights that he may have, he may disclaim. So a good example is the company has a lease over a property for 5 years, and within the course of these 5 years, he has to be paying property taxes, NEPA bills, security levies, and all that. The company has only occupied that property for 6 months, and it goes into liquidation. He may not want to bother himself with that property. As far as he's concerned, it's going to be more of a waste than an asset. He can disclaim it. Any asset that is, any contract that is unprofitable, or any other property, any contract that is unprofitable, or any other property that is unsaleable or not readily saleable, or is such that it may give rise to the performance of any onerous act or liability for the payment of any such money, then with the leave of the court, that liquidator may be able to disclaim that property. So the liquidator, notwithstanding that he has endeavored to sell it or taking possession of the property or exercise any act of ownership in relation thereto, may, with the leave of the court and subject to the provisions of this section, in writing signed by him within 12 months after the commencement of winding up, or such extended periods as may be allowed by the court, he may disclaim the property, provided that when the property has not come up to the knowledge of the liquidator within 1 month after the commencement of the winding up, the power under this section of disclaiming the property may be exercised at any time within 12 months after he becomes aware. A disclaimer determines the rights, interests, and liabilities of the company in or in respect of the property disclaimed, but shall not, except it is necessary for the purpose of releasing the company from liability, affect the rights or liabilities of any other person. So a classic example is the company has leased the property for 5 years, and they are saying, now, wow, how are we going to be paying property taxes and many other financial obligations that will come with this lease? But the company has a license, an oil block, oil mining lease, and every year they have to pay ground rent, and let's say other expenses that may go with it, contributions to decommissioning and abandonment fund, environmental remediation fund, local content obligations, and then there's one I'm even thinking of now, host communities obligations. And this company is being liquidated, and the liquidator looks and says, until this thing is done, how can I be paying and decommissioning and abandonment and payments? They are just going to be too hectic. It's onerous. It is not positive. It's going to impose more obligations. So with the leave of the court, I can hands off. The law allows companies that are dying to hands off even interest that they may have in these licenses. So, but if, for example, this company that is handing off from this property has already subleased the property or the license, the oil mining lease to another company, your disclaimer will not affect the right of that other company. That's what we are saying. So if Shell has an oil block for 20 years, and then it has entered into a sublease contract with Renaissance. Renaissance still has 5 years on expired term over that lease. The fact that Shell says we are handing off will not automatically affect the rights of Renaissance, notwithstanding that Renaissance claims its interest directly from Shell. So that is what I felt we should know about that. The court may require notices to be given to persons interested and impose such terms as a condition of granting leave and make such other orders as it deems just. So the court will not just allow you to disclaim that unprofitable contract or your interest in property. There must be notice so that persons interested can come and say their own part. Again, a person interested in a property may ask a liquidator to disclaim, and the liquidator usually will do this within 20 days. If he fails to apply for leave to disclaim within that period, the liquidator loses the rights to disclaim. And in the case of a contract, the company is deemed to have adopted it. So this prevents liquidators from delaying to the prejudice of others. So take your time and look at the law relating to disclaiming onerous property. See what it means to disclaim is to formally and legally renounce or abandon property or a contract so that the company ceases to have any rights, interests, or liabilities in respect of it, and all that. Okay. So let's now jump into transactions at an undervalue. I hope somebody's getting something from the class. Transactions at an undervalue, section 659. Like I said, when the company is about to be liquidated or is having insolvency issues, and a liquidator or an administrator is appointed, he begins to go through the books of the company and he discovers that the vehicles of the company have been sold to the director's wife for next to nothing. He can challenge it. So the liquidator or administrator may challenge a gift or transaction that is made at an undervalue if he can prove that the company received no consideration or the consideration it received is significantly less than its true value. He will pray the court to grant an order aimed at restoring the position to which it would have been if the company had not entered into that transaction. So the company may have some defenses. Number one, the transaction was entered into in good faith and for the purpose of carrying on the company's business. That at the time it did so, there were reasonable grounds for believing that the transaction would benefit the company. Essentially, I did it with a good mind. Of course, if the person you are transacting with is connected to the company, again, it will be hard to prove that you did it with a good mind. The time of the transaction, again, is relevant if the company entered into it within 2 years. Yes, the 2 years I was talking about when we come to fraudulent preference. Here, section 659 gives us 2 years, while the other section dealing with fraudulent preference, section 658, does not give us any year. It only says a period of years. And I'm saying that you have to read 2 years into that because that is what you see in England. That is what you see in Kama 1990. And definitely that must have been an error from the drafters of the law. So let's just move on and see if we can round up quickly. So the time of the transaction is relevant if the company entered into it within 2 years, ending with the onset of insolvency, between the making of an administration application and the time the administration order is made, between the filing with the court of a copy of notice to intention to appoint an administrator and the making of the appointment. So within 2 years, ending to the onset of insolvency, if you start to enter into all these funny transactions, then we can challenge that transaction as a transaction at an undervalue. If it is 3 years before the onset of insolvency, even if you want to challenge it, it's not under this section. Again, a company is having issues and somebody is rushing to court to say, "My Lord, appoint an administrator." From the time this administration application is made to when the order is granted, it can take 6 months. Judges keep adjourning. It can take 2 months. Some judges are very prompt and quick. From the onset of insolvency till the judge now makes this order, all the assets of the company have been reduced to next to nothing. Then we'll say, okay, those are transactions at an undervalue, and we will ask the judge to avoid them. Note that when a company transacts at an undervalue within 2 years, ending with the onset of insolvency, the 2-year period is not a relevant time unless the company is at the time unable to pay its debts or becomes unable to pay its debts in consequence of the transaction of preference. But the requirements of the subsection are presumed to be satisfied in relation to any transaction at an undervalue entered with a connected person unless the contrary again is shown. In essence, even if an undervalued transaction is made within the 2 years period, the period will not count as relevant time unless we can establish insolvency. Okay, so please let's continue. But I believe you get the gist of it. Get the gist of it. Okay, so now let's move to 2 quick topics, subtopics, what we call fraudulent trading, and then what we call wrongful trading. Again, a company is being dissolved, a company is insolvent, a liquidator is appointed, an official receiver is appointed, and these persons begin to go through the documents of the company. They now discover that the directors of this company have been very fraudulent in the management of the company. There has been a lot of fraudulent trading, and creditors have been defrauded. They manage this company recklessly. They run this company down. Those persons can bring an application before the court to say anybody who was complicit to this act of wickedness, of wrongdoing, should come and bear liability. And usually this liability is done without limitation. So if the company has lost 1 billion, the court can say you should pay the 1 billion. There's no cap. So in essence, that's what fraudulent trading is all about. So it creates a civil liability and it creates a criminal liability. On top of asking you to come and bear civil liability without limitation, the judge can also say, "Okay, go to prison. You're a bad man." So there's a criminal element and then there's a civil element. So I run through my slide. If it is revealed during winding up that the business of a company was carried out recklessly, number 1, that is the first element. 2, or with intention to defraud creditors or any other person. Or 3, for any fraudulent purpose. You manage this company recklessly. You manage it with the intention to defraud creditors or any other person. 3, you manage it for any fraudulent purpose. The court, acting on the application of the official receiver or the liquidator or creditors or contributories, may, if it deems proper, declare that any person who was knowingly a party to such acts should bear personal responsibility without limitation of liability for all or any of the debts or the liabilities of the company as it may direct. I think that is very clear. Note that fraudulent trading may apply to anybody, employees, officers, agents, directors, etc. Furthermore, the court may provide that the liability of any such person under the declaration shall be a charge on any debt obligation due from the company to him, on any mortgage, charge or interest in any mortgage, or charge or assets of the company held by or vested in him, or any company or person on his behalf. Essentially, the court is saying, "Oga, you are a bad man. You have been involved in fraudulent trading. If this company was having 2 naira belonging to you, that's your 2 naira, they will use it to sort out that money. If this company was holding your property, or you had a charge, you had a mortgage over a property was held, your property was held, or property was held in your benefits, that benefit can now be used to satisfy this money that you are now due to pay, or this money that is now to be used to pay or to discharge the company's obligation." So furthermore, the court may provide that the liability of any such person under the declaration shall be a charge, a charge, a control on any debt obligation due from the company to him, number 1. 2, a charge on any mortgage, charge or interest in any mortgage or charge or assets of the company held by or vested in him. So you already have a charge vested in you. The court can now say that charge that you have in your interests against this company, or it could even be against any other company, that charge that you have against that property will now be subjected to a superior charge that the company will have. So the company will now have an overriding charge over a charge that you have against any other property or mortgage. 3, a charge or any person claiming as assignee from or through the person liable, or any company or person acting on his behalf, essentially, what is yours will now be used for the benefit of the company. And the court may make any further orders necessary for enforcing any charge imposed. So I hope you get what we're trying to say, that the company, a person who is involved in wrongful trading can be asked without limitation of liabilities. Yoga, you have run this company recklessly, fraudulently, or with the intention of defrauding creditors or for any fraudulent purpose. As a result of that, this company and its creditors or even its shareholders have suffered. So you will bear liability. You bear unlimited liability, or you bear liability to the extent that the judge will order or decide. And in so doing, the judge is now saying that everything that is due to you cannot be used, taken from you by force. The company has an automatic charge over your own assets, over your own money, over your own charge in another mortgage, or or the company has a charge over another interest that somebody else is holding on your behalf. That thing will bring it and use it to settle your indebtedness. I hope with these few words of mine, you have gotten the gist. Don't manage a company recklessly, jaga anyhow. Don't manage a company with the intention of defrauding creditors. Don't manage a company for any fraudulent purpose at all. And I told you that fraudulent trading can be criminalized, and you can send you to prison for not more than 2 years, or you pay a fine. But you not go to prison if you manage the company recklessly. If you manage the company to defraud creditors or for a fraudulent purpose, then you can be criminalized. So it's not every act of fraudulent trading that can be criminalized. If it was a reckless act of fraudulent trading, it cannot be criminalized. But if it was a fraudulent act of fraudulent trading, then it can be criminalized. So in addition to civil liability, you can also go to prison or pay fine. The court may make a civil declaration of liability against a person for fraudulent trading, even if that person can also be criminally prosecuted. So the fact that this man is likely to go to prison for this wickedness does not stop the judge from saying, Oga, still pay that money. So the declaration will count as a final judgment of the court. Very, very important. The moment the judge has found you guilty of fraudulent trading, another prosecution now that wants you to go to prison will not have to start to prove the case afresh. That declaration of the judge is a final judgment. Of course, you can appeal against it. It's not an interim judgment. That's what we mean. You can appeal to Court of Appeal, but it's a final judgment. So ideally, that judge who is finding you liable for fraudulent trading should also convict you at the same time. That is my thinking. But again, judges don't act so much. It's a criminal matter. If a prosecutor now takes that judgment of the court, because remember that here is an application brought by the official receiver or liquidator, creditor, or contributory. These are not criminal prosecutors, it's not a criminal proceedings. But you may have to prove a criminal element which must be established beyond reasonable doubt. To establish fraud or fraudulent purpose beyond reasonable doubt. Recklessly, maybe not. Maybe on the balance of probabilities. So having established the guilt of that person of fraudulent purpose or fraudulent intention to defraud creditors beyond reasonable doubt, and the judge now declares that Johnson is liable to pay creditors or to pay the company for having been involved in fraudulent trading as a result of his act of fraud or fraudulent intention. That decision of the judge is a final judgment. A prosecutor and Ministry for Justice can take that judgment and bring it before the court to say, my lord, on the basis of this finding, convict and send this bad man to prison. It's a final judgment. It will not need further proof. The official receiver or liquidator, LA, that's why they put LA, that should be liquidator, may give evidence or call witnesses. May give evidence or call witnesses when he's challenging you for having been involved in fraudulent trading. May give evidence, may call witness. What of the contributory and creditor? Why can't they? So that is something I'll look up. So the assignee of a person guilty or liable for fraudulent trading includes any person to whom, on whose favor by the direction of the defaulter, the debt, obligation, mortgage, or charge was created, issued. So if you are now guilty of fraudulent trading, you quickly carry your assets and give to somebody to put it away from the reach of the law. That person is deemed to be your assignee, and all that assets you give to him will be brought under the subjection of the company that you have wrongfully defrauded. But it does not include an assignee for valuable consideration given in good faith and without notice of any matters on the ground of which the declaration is. That bona fide purchaser for value, not me anyway, somebody has been involved in fraudulent trading in the course of which he has made some money, or he has acquired an asset which he has title to that asset which he has now sold to an innocent person without notice. The charge that the court will not deliver or declare in favor of the company cannot extend to that. And the reasons why you have done land law and all that. So again, valuable consideration does not include consideration by way of marriage. So transfers made on that basis are not protected. So you have fraudulently acquired property, and now when you marry, you sign a document with your wife and give the property to her. Madam, that one no follow. The man thief the money, send it back to the company. Valuable consideration does not include consideration by way of marriage. Let's continue. Okay, so let's say something about wrongful trading. Wrongful trading. Establishing fraudulent trading is not always easy, because most of the time you have to establish fraud beyond reasonable doubt, except your allegation is on recklessness. Either way, it's not always easy. So recently they brought in, and this was in the 80s in the UK, they brought in a second wrongdoing, a second wrong referred to as wrongful trading. So the intention of this. Okay, my dear students. So wrongful trading, we try to say this is a bit limited, but easier to establish. The focus is on directors. When a company is beginning to go down, you shouldn't start trading. You're like a woman who knows that she has HIV should not go and marry, or a man that knows that he has HIV. That is wrong, because you have information the other person doesn't have. A man who knows that he's impotent, why should he go to marry? A woman who knows that her womb has been removed, why will you go and marry and not tell somebody? You want to enter into a marriage and you have some very crucial information. You know that the other person knows SSS and all that business. SS. You must be truthful. Tell the person the position. Then if the person wants to go ahead to marry you, it's different. You want to marry the person, he will never trust you forever. She will never trust you forever. On the application, section 673 of a liquidator, the court may require a director to contribute to the assets of a company that goes into insolvent liquidation. If at some point before winding up, the said director knew or ought to have known that there was no reasonable prospect of this company avoiding insolvent liquidation, then he shouldn't have traded. Somebody now wants to supply some goods to this company on credit, thinking that the company is a valid company, everything is okay. Meanwhile, the directors have inside information. They know that the company is going down. They now tell the man, supply goods. We are going to pay you within a period of 5 years. You know that this company is going down in 2 months' time. You're a bad man. you have to come and pay. But I don't know why they now limit it to only directors. I would have felt all officers and all persons who are complicit to this wrongdoing should have to bear liability, and not only directors. Defense. He took every step to minimize losses to creditors. He took every step to minimize losses to creditors. I wonder what they mean by those steps. He took every step to minimize losses. That is the defense. So remember, the law says he knew or ought to have known. What should he know, or what should he have ought to known? The things he should know, or the things he ought to have known, are the things that a normal director of a company going through the company's documents and books would have known. Secondly, him being a director of, let me assume he's a director of with a PhD in finance, or a director with PhD in accounting. As a director, these are things he already knows. First of all, there are things he ought to have known. Every diligent, hardworking, prudent director would have known. Then, if those other directors would have known, then we say you or Oga is supposed to know. Why? Every other director for still know. Say this company, they go down. You're supposed to know. Secondly, you, Oga, you are a director of finance. You, Oga, you have a PhD in accounting. Going through these books of this company, there's no way you will not have known. So I read what we have here. The facts you ought to know are certain. The conclusions you ought to reach and the steps you ought to take are those which would have been known or ascertained or reached or taken by a reasonably diligent person, having the general knowledge, skill, and experience that may reasonably be expected of a person carrying out the same functions as are carried out by that director in relation to the company, and the general knowledge, skill, and experience that the director himself has. Oga, you have been trained in India, China about corporate finance. You have worked in corporate finance for 30 years. So your general knowledge is what is now punishing you. So that is what I felt you should know. Thank you, Lord. I'm almost done. Bear with this lecturer. He's heading somewhere. Okay, so yeah, if you look at section 674, 675, 280, the liquidator, official, receiver, creditor, or contributory may ask the officers, promoters, or liquidators who misapply, retain, or become accountable for funds and should pay, or essentially, if as a director, if as a liquidator, I now discover that those people who are on top of this company have misapplied the company's funds, and then I can ask the court to order them to restore it. The liquidator may also ask the Attorney General to prosecute you if there's fraud. The liquidator or the official receiver may also ask the court to disqualify you from being a director of the company. So I think we'll call it a day. Employees and insolvency. Look at my book. Employees are very, very vulnerable from the time that the liquidation order is granted by the court. The rule is that employees lose their office. You are essentially sacked. Look at Bedu versus Itier. The compulsory winding up order not only dismisses the directors and dissolves the management of the company, it also ipso facto terminates the employment of all the employees. On the making of the winding up order, the servants of the company are ipso facto dismissed. Once the order is made, you have lost your job. Employees may also lose their entitlements and pensions as such. Even though employees and other unsecured creditors have some rights against the company, they are still in greater jeopardy because they do not have direct rights of recourse against the assets of such company. And even the provision in section 657 on priority only deals with junior staff. You know that already. Finally, I think I'll just leave you here. Sections 692, 699, 700, 701, 703. Look at my book. Defunct and unregistered companies can also be wound up, similar to the way you wind up a company by the courts, a defunct company that is not trading. They are not doing anything. They can ask CAC to strike them off, or CAC, if it is convinced that they are not doing business, can also wind them up, strike them off, not wind up, sorry, strike off the name of the company. It's a moribund company. There are some few procedures that you have to follow. So, my dear students, I want to thank you for your time. We will stop here. You go through these things. I'm going to tell you where not to read for the exam and the things I want you to look out for with respect to liquidation. It is quite broad, but if you go through my first lecture and this one, and the next one I will send will just be for 30 minutes, at least you should be able to have some general understanding of the procedure for winding up of companies and some of the consequences and then the wrongdoing that may occur. Today, we have tried to look at priority in insolvency, pointing out that because the assets of the company are limited, it is crucial that we have rules on sharing. Who takes first? Do we pay all of them at once? The law says no. Pay some first. Who do we pay first? Secured. If it's a fixed charge holder, he goes after the asset of the company. If the assets of the company are not sufficient, then we go after, we sell all those assets, and then we pay the fixed charge holder first. Then we sort out expenses of winding up. After we sort out expenses of winding up, we pay preferential creditors. When we are done with them, we pay floating charge holders. When we are done with them, we pay unsecured creditors. All unsecured creditors are put in the same pool, and you pay them equally. The money is not enough, pay them in proportion to what the company is owing them. The same with preferential creditors. Put all of them in the same pool and settle them first. If the money is not enough, pay them in priority. For floating charge holders, you don't put them in the same pool. The one that comes first, you pay. Equities, you know where equities conflict, then the first in time prevails. So after I've sorted them all out, you come to unsecured creditors. If anything is still left, you come to preferential creditors. Put all of them in the same pool. There's no priority with respect to time. When you are done with that, you come to equity shareholders. Should be ordinary usually, or deferred shareholders. After that, we now looked at the rules relating to transaction at an undervalue. You have the whole understanding. If the company transacts in such a way that there is no benefit to the company, or the benefit is paltry, laughable, then Oga, bring back those properties. The aim is restitution. Put the company the way it was before that transaction at an undervalue was done. And usually for this to happen, the transaction must have been entered into when insolvency has started, usually from the onset of insolvency. For a person connected to the company, we say 2 years leading to insolvency. For any other case, it's usually 3 months. Then we also looked at fraudulent preference. During insolvency, again, don't give one person undue advantage over the other. It is not fair. It is unjust. Put all of them on the same plane. So if you try to do that, to give one creditor access, priority, give him a fixed charge, give him a floating charge, and all that, create some kind of, pay him quickly, sort out his own matter quickly, all that is cancelled. Bring everything and keep it back the way it was at the onset of insolvency. Don't scramble to give one person an edge. So the role of the court, again, in this case, is to bring everybody to the same position, nullify all that was done. You are just wasting your time. We also looked at floating charges from 3 months to the time the company is being liquidated. Don't create a floating charge unless the person that you're creating the charge in his favor actually brings money. And then we now look at fraudulent trading. Don't enter into trade recklessly, fraudulently, with an intention to defraud creditors, or don't manage this company for any fraudulent purpose. If you do that, Oga, director, any other person, employee, whoever you are, the judge can impose upon you unlimited liability, and in doing so, we give the company a charge over any interest that you have, either in the company or elsewhere. Then lastly, we said not only that, you may go to prison for up to 2 years if you are convicted for fraudulent intent or fraudulent purpose. Lastly, we now looked at wrongful trading. And we said that wrongful trading applies only to directors. Directors who manage a company. You know that this company is going down, you continue to trade. Oga, you will pay the money to that creditor. Unless you can prove that you did everything reasonably possible to minimize losses to creditors. So I will leave you here. I will send you my slide if you are interested in them. Thank you. Till I send you the next slide. Have a lovely Christmas, and I miss you already.